Morning. Are you Howard Dwayne Walker Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Walker, in clause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was gonna email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as
Yes.
possible, and because the case has to get closed out,
Right.
then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to take these?
But that's what's alleged is that and how.
Thank you.
Thank you,
And
Nancy.
may I excused?
Yes, thank you. And Mr. Parker, you've got Gabriel Cruz.
Ma'am.
So.
Good morning.
Gabriel Cruz.
And I've got 2
Sentences.
and a dismissal on one. Is that right?
Sheriff, why'd you let me do that? He said, what'd you do? I said, I came over here, I had to just on the page. No.
I knew you did, Mr. Bishop.
I was trying to get him.
I mean, I thought about it.
I didn't even look.
Good progress for you.
I still think back to the day when the Boston High used to walked in here on it.
Oh, yeah. Good morning. Are you Gabriel Cruz III?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in clause number 26, DCCR 0373, you're charged with a 3rd-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they charged you with?
yes.
And then in clause number 26, DCCR 0374, you're charged with the 3rd-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes,
And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060. And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
State tenders number one in each case.
No, Judge.
It's admitted in each case. Is there any evidence that Mr. Cruz is not competent?
No, Your Honor.
And Mr. Cruz, do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State, sorry, we already did that. All right, I'm going to find, Mr. Cruz, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report that'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Mark Hebert, Mr. Parker, it's a sentencing.
Yeah. I thought it's probation officer, the kitchen's fine. Ashley. You just write out it. Yes, but not.
Man that you were talking to behind you. Is that Mr. Celestine?
No, that's the father of Hakeem Dolls.
Okay. He lives over there. I was curious.
Good morning. Are you Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court and entered pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 in a motion to revoke his probation. He's on probation for driving while intoxicated, third or more. This was unagreed. I've received the updated pre-sentence report. If you both had an opportunity to review that report.
You have, Your Honor.
Judge. Any additions or corrections to the report?
None more, Judge.
Mr. Parker?
Judge, I mean, my intention, excuse me, was that, and what Ms. Malfina and I talked about is that he had some serious health conditions. He ended up using drugs. I don't know how long he had been using drugs in the past. He and I had a heart-to-heart talk, explain the situation he's in, and we talked about Safe P being a great option for him. Now, you know, his mind has changed, and I like to let him address the court, but he said being in jail, he's been in there for a while now. He said his mind's clear, and he was here before on oxygen, and he's able to breathe better with his emphysema and all the other issues that he's had. But he's indicated he just wants to take his time. And my position is that, I mean, I personally think safety is probably the best thing for him. But at the same time, if he doesn't want it and then why take him to bed? Ms. Bells could use it. I'd like to let him address the court, Judge.
So, Mr. Hebert, the recommendation was for potentially Safe P and to get you that help. Are you saying you don't want that?
I'd like to just go back to probation and get help from home.
Well, that's not gonna
That's
happen.
okay.
Yeah, so it's either Safe P or prison.
Safety. Yes, ma'am.
So here's the thing about Safe P. It's an expensive program. And I don't want you to, kind of like what Mr. Parker said, go just take up a bed and we pay $70,000, $80,000 for you to go and you don't get what you need out of it. If you don't go in with the right mindset, then it's going to be a waste of everyone's time. If you want that help, I'm willing to give it to you.
Yes, ma'am. Please.
Ms. Malfino?
And if I may respond to one other thing, I think part of his attitude was when he did the PSI is that he was like, you know, I'm on drugs. And I think maybe now that he's been there, he's cleaned up a little bit and not on drugs and realized that the help, he really needs that. And
Yeah, I mean, you
That's why
tested
it's
positive 1 month after having an
Mhm.
angioplasty and a stent. You started using drugs again. So obviously you need some help
Yes, ma'am.
if you're doing that 1 month after that kind of scare. So,
Yes, ma'am.
Ms. Malfino, anything to add?
No.
So, Mr. Hebert, I'm going to give you this opportunity. And I hope you take advantage of it. I'm going to find that you entered your pleas of true, freely and voluntarily, find all of those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. Let's see, you were put on in September 25. I'm going to order that, as a condition of your probation, you enter and successfully complete the safety program. If there are still ongoing medical needs, then they'll put you in the special needs safety to make sure that any of that's taken care of as well. So I'll let them determine which one, but it probably would be the special needs if you're still having some ongoing health issues. This is your opportunity to get clean, live the rest of your life, finish your probation, and not go to prison.
I appreciate it. Thank
You're
you.
not going to get an opportunity like this again, so take advantage of it.
Yes, ma'am.
So this was not an agreement. So I'm going to hand you the trial court certification. You have some rights to appeal. Can't imagine that you would since I just did what you asked me to do, but here is, if y'all will sign the bottom and then just give him the bottom.
Any other?
It will-
Brent Smith.
Thank you, Judge.
Thank you, Judge.
Good morning. Are you Brent Smith?
Yes.
And this is cause number 26 DCCR 0128. Mr. Smith was previously in court, entered a plea of guilty to burglary of a habitation. It was an agreement. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
None more, Judge.
Not from the state.
Concern here is the drug issue and the type of drug specifically with PCP, and I'm not real sure that. I'm just considering potentially ISF for some treatment.
That was part of the recommendation.
I don't see that. I thought it was, I don't,
ISF substance abuse.
It was part of the,
okay, well, it's not on here, but that's what made sense to me, so,
Yes, ma'am, that was part of the deal. That was
Okay.
the only reason probation was
Yeah.
offered in this case.
okay. Got it. All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the ISF Substance Abuse Track Program. And then once you're released from that, you'll be on the specialized mental health caseload and be required to follow all of the rules, all of the recommended treatment, including medication. Whether you feel like it's something you need or want, if they recommend it, it's going to be part of your probation that you have to follow all of those rules and recommendations. Do you understand? It looks like any other follow-up treatment from after ISF. And obviously you are to remain away from 4325 Galveston Street. You cannot be anywhere near that location. Do you understand? All right, I'm going to hand you the trial court certification. It shows this was an agreement that I followed and you waived your right to appeal. You're very lucky, sir. Because the house that you broke into, most houses that you break into nowadays, you could end up with someone taking care of that on their own, especially if you enter into a law enforcement officer's house and traumatize them, their family. So do you understand the seriousness of this? So if you do everything you're supposed to on this probation, this is a great opportunity. You don't have the conviction on your record. We're going to get you the help you need. You can be successful. But the other side of that is if you violate any condition of probation at all, you will be back here in court. You could be found guilty of the offense and sent to prison anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? All right, and go back with the bailiff.
thank you, Judge.
Good morning. Are you Hillary Davis? And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Davis, in cause number 23, DCCR 1551, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for credit debit card abuse, state jail felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance, penalty group 1-1B, April 29th of 2026. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically that you were at a place where a criminal act was being committed and you were accompanied by a co-defendant named Jonathan Rito. Is that true or not true?
True.
Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true? Sorry. Count 4 alleges that you possessed a drug, cocaine, April 29th of 2026. And is that true or not true? Count 5 alleges that you admitted to your probation officer that you used illegal drugs, marijuana and cocaine, April 21st of 2026. And is that true or not true? Count 6 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you tested positive on April 10th of 2026 for cocaine and marijuana. And is that true or not true? Count 7 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? True, you said, I'm sorry?
True.
Count 8 alleges that you were at a location other than your residence at approximately 1:56 a.m., April 29th of 2026. Is that true or not true? Count 9 alleges that you are behind in your payment of restitution as of May 19th, 2026 in the amount of $297.50. Is that true or not true?
True.
And then count 10 alleges that you failed to pay court assessed fees as directed, and as of May 19th of 2026, you're $2,128 in behind. Is that true or not true? Did you enter your pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? And it looks like that agreement is for a cap of 18 months in the state jail prison, which means we'll come back. I'll get an updated report from probation, have a hearing on sentencing at a later date. As long as I give you 18 months or less, then you're waiving that right to appeal. Is that what you want to do? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Davis is not competent?
There you are.
All right, ma'am, I'm going to find that you entered the pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily. Find this counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing. Ask the probation department to do an updated report. Anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you're welcome. You can go back with the bailiff. Do you anticipate a hearing, any information with regard to count 1? Are you gonna?
Judge, it's a drug case and labs probably haven't even come back yet.
Okay. I mean, that's fine. She's
I'll
meant
try.
everything else, so.
Got to get the ultrasound. If they do the neck test, I can provide.
If you think you're gonna get it, just let us know. We can do it at 11 o'clock or something, but for now, we'll just do it on a regular docket. Thank you.
3 very different outcomes, but the same courtroom principle runs through all of them. A guilty plea or probation violation doesn't automatically end the judge's decision-making. Walker received 22 years after pleading guilty to injury to a child. Cruz pleaded guilty to stalking and violating a protective order, with sentencing postponed for a pre-sentence report. Hirt was given another opportunity through treatment instead of immediate prison, while Davis had her probation revoked based on multiple violations, with sentencing still to come. The court is balancing accountability, public safety, and the possibility of rehabilitation. And every condition matters. Which judge's decision surprised you the most? Let me know in the comments. Hit like if you found this breakdown useful, and subscribe for more real courtroom moments and legal breakdowns.